The Health Information Portability and Accountability Act, HIPAA, Privacy Rule Overview, an educational presentation brought to you by the Hawaii Health Information Exchange, May 24, 2022. This material is presented for educational purposes only and is not intended to be a solicitation for services or legal advice. The purpose of this presentation is to provide an overview of the HIPAA privacy rule related to interoperability and the exchange of health information. It is not intended to be a review of the entire rule, and viewers should consult their organization's policies before acting on anything discussed in this presentation. The HIPAA privacy rule is a federal regulation signed into law in August 1996. It establishes rules related to the appropriate use and disclosure of individually identifiable health information, IIHI, more commonly referred to as protected health information, PHI, and personally identifiable information, PII. It is the primary federal privacy regulation governing health information. There are other regulations that also address privacy issues, such as the Privacy Act of 1974, which applies to federal government agencies, and 42 CFR Part 2, the Substance Abuse and Mental Health Services Administration Act, which puts restrictions on the disclosure of substance abuse and mental health patient information. HIPAA provides many rights to individuals related to how their information is used and disclosed. It requires covered entities and their business associate partners to maintain adequate administrative, technical, and physical controls to properly protect and secure PHI. HIPAA is the floor upon which more stringent state regulations may be layered, provided that state law does not contradict what HIPAA says. In the case, HIPAA preempts state law. The Hawaii Healthcare Privacy Harmonization Act says that if a covered entity is compliant with HIPAA, then it is compliant with many state privacy regulations. Certain privacy laws related to domestic abuse and treatment of minors are not covered by this act. This general leveling of the playing field ensures that decisions made related to healthcare privacy within the state of Hawaii are consistent at both the federal and local levels. A major goal of the privacy rule is to assure that individuals' health information is properly protected, while allowing the flow of health information needed to provide and promote high-quality health care and to protect the public's health and well-being. This balance is highlighted by the use of the words portability and accountability in the name. The rule strikes a balance that permits important uses of information, while protecting the privacy of people who seek care and healing. The rule is designed to be flexible and comprehensive to cover the variety of uses and disclosures that need to be addressed. Covered entities come in all sizes, and how they comply with the regulation will vary. Covered entities need to be able to demonstrate that they are complying with the requirements of the regulations, while remaining true to the principle of portability of health information. The privacy rule, as well as all the administrative simplification rules, apply to health plans, healthcare clearinghouses, and to any healthcare provider who transmits health information in electronic form in connection with transactions covered under HIPAA. They are called covered entities. Health plans include individual and group plans that provide or pay the cost of medical care are covered entities. These include but are not limited to health maintenance organizations, HMOs, Medicare, Medicaid, Medicare Plus Choice and Medicare Supplement insurers, and long-term care insurers. Every healthcare provider, regardless of size, who electronically transmits health information in connection with certain transactions, is a covered entity. These transactions include any transactions for which HHS has established standards under the HIPAA Transactions Rule. The privacy rule covers a healthcare provider whether it electronically transmits these transactions directly or uses a billing service or other third party to do so on its behalf. Healthcare clearinghouses are entities that process non-standard information they receive from another entity into a standard transaction, or vice versa. In most instances, healthcare clearinghouses will receive individually identifiable health information only when they are providing these processing services to a health plan or a healthcare provider as a business associate. Business associates of providers and health plans must comply with portions of the privacy rule. Business associates are individuals or entities that perform functions or provide services on behalf of covered entities, other than in the capacity of a member of the workforce, and that create, receive, maintain, or transmit PHI in the course of providing those services. When a covered entity uses a contractor or other non-workforce member to perform business associate services or activities, the rule requires that the covered entity include certain protections for the information in a business associate agreement. In the business associate agreement, a covered entity must impose specified written safeguards on the individually identifiable health information used or disclosed by its business associates. The privacy rule established that core permitted uses and disclosures of PHI are for treatment, payment, and healthcare operations. Functions that fall under these categories do not require written patient consent before PHI can be disclosed. Historically, treatment has been performed by providers, payment by health plans, and healthcare operations by all types of covered entities. Payment transformation is blurring these lines and causing covered entities to perform functions in multiple categories in order to support wellness, interoperability, and patient access. The HIPAA privacy rule protects PHI independent of form or format. This means that PHI in written, electronic, and verbal form is subject to privacy rules. This differs from HIPAA security, which only applies to PHI in electronic form. Covered entities must make reasonable efforts to use and disclose the minimum amount of PHI necessary to accomplish its purpose. This means that only the minimum amount of information required to satisfy a particular purpose may be used or disclosed in order to carry out a function. It also means that just because a person works for a covered entity or business associate does not mean they automatically have the right to see PHI. Covered entities must meet privacy rule compliance requirements, including having appropriate policies and procedures, training employees, and naming a privacy official. Preparation is thus essential to being able to demonstrate compliance with the privacy rule. HIPAA privacy established many protections for individuals. Prior to its passage, health organizations were left to establish their own rules related to what needed to be disclosed to patients. Taken together, the protections provided under HIPAA ensure that patients could count on receiving at least a minimum amount of information when they needed to receive healthcare services. The key protections are: individuals have a general right to review and obtain a copy of their PHI that is stored in a designated record set. Individuals can request covered entities to amend their PHI when information is inaccurate or incomplete. Individuals have a right to receive an accounting of all disclosures of their PHI made by a covered entity or their business associate to a third party. Individuals may request restrictions on disclosure of PHI, except when disclosures fall under the treatment, payment, or healthcare operations categories, or as otherwise stipulated by HIPAA. Individuals may request alternative means or locations for receiving communications containing PHI. Individuals may assign a personal representative to act on their behalf. Covered entities need to publish and maintain as current a notice of privacy practices that must describe the ways in which the covered entity may use and disclose protected health information, must state the covered entity's duties to protect privacy, must describe individuals' rights, including the right to complain to HHS and to the covered entity if they believe their privacy rights have been violated, and must include a point of contact for further information and for making complaints to the covered entity. Covered entities must act in accordance with their notices. HHS expects that covered entities meet the following administrative requirements in order to demonstrate compliance with the privacy rule. HHS recognizes that organizations come in all sizes and so does not expect all organizations to demonstrate compliance in the same manner. Privacy policies and procedures. A covered entity must develop and implement written privacy policies and procedures that are consistent with the privacy rule. Privacy personnel. A covered entity must designate a privacy official responsible for developing and implementing its privacy policies and procedures, and a contact person or contact office responsible for receiving complaints and providing individuals with information on the covered entity's privacy practices. Workforce training and management. A covered entity must train all workforce members, which includes employees, volunteers, trainees, and potentially others under the direct control of the entity, on its privacy policies and procedures, as necessary and appropriate for them to carry out their functions. A covered entity must have and apply appropriate sanctions against workforce members who violate its privacy policies and procedures or the privacy rule. Mitigation. A covered entity must mitigate, to the extent practicable, any harmful effect it learns was caused by use or disclosure of protected health information by its workforce or its business associates in violation of its privacy policies and procedures or the privacy rule. Data safeguards. A covered entity must maintain reasonable and appropriate administrative, technical, and physical safeguards to prevent intentional or unintentional use or disclosure of protected health information in violation of the privacy rule, and to limit its incidental use and disclosure pursuant to otherwise permitted or required use or disclosure. For example, such safeguards might include shredding documents containing protected health information before discarding them, securing medical records with lock and key or passcode, and limiting access to keys or passcodes. Complaints. A covered entity must have procedures for individuals to complain about its compliance with its privacy policies and procedures and the privacy rule. Among other things, the covered entity must identify to whom individuals can submit complaints to at the covered entity, and advise that complaints also can be submitted to the Secretary of HHS. Retaliation and waiver. A covered entity may not retaliate against a person for exercising rights provided by the privacy rule, for assisting in an investigation by HHS or another appropriate authority, or for opposing an act or practice that the person believes in good faith violates the privacy rule. A covered entity may not require an individual to waive any right under the privacy rule as a condition for obtaining treatment, payment, and enrollment or benefits eligibility. Documentation and record retention. A covered entity must maintain, until 6 years after the later of the date of their creation or last effective date, its privacy policies and procedures, its privacy practices notices, disposition of complaints, and other actions, activities, and designations that the privacy rule requires to be documented. The Department of Health and Human Services, Office for Civil Rights, OCR, is responsible for administering and enforcing HIPAA standards and may conduct complaint investigations and compliance reviews. HIPAA provides for both civil and criminal penalties for willful violations. If a complaint is filed, OCR works with the covered entity or business associate to determine if corrective action is possible. Monetary penalties are applied as the willfulness of violations increase, or as cooperation decreases. As of April 2022, OCR had received 296,419 HIPAA complaints and has initiated over 1,129 compliance reviews. Of these, OCR settled or imposed monetary penalties in 110 cases, resulting in a total dollar amount of $131,563,132. The Department of Justice oversees violations that are criminal in nature. Employees and other principals of covered entities who knowingly obtain or disclose individually identifiable health information in violation of the Administrative Simplification Regulations, who commit offenses under false pretenses, or who commit offenses with a profit motive, could face criminal charges. Conviction of a criminal offense could result in fines of up to $250,000 and imprisonment for up to 10 years. The Hawaii Healthcare Privacy Harmonization Act, HRS Chapter 323B, states that if a covered entity complies with HIPAA, it is generally deemed to be in compliance with all state laws relating to the use, disclosure, or confidentiality of PHI. This act harmonizes the language from over 50 different laws and rules that were implemented over a long period of time. It went a long way in removing inconsistencies in language and obligations and provided a common basis for interpreting compliance at both the federal and state levels. There are a number of notable exceptions for state laws that were felt to be more stringent than HIPAA or that dealt with a higher risk segment of the population. Input from privacy professionals familiar with Hawaii state law is still required when dealing with situations that involve minors, abuse, or communicable diseases. HIPAA, more than any other regulation, sets the tone when it comes to the portability and accountability of health information. Few other industries have this type of overarching federal privacy regulation. This is important given the sensitivity that health information carries, and the fact that all of us depend on the healthcare industry from the moment we are born to the day we die. Understanding HIPAA is essential to understanding good quality healthcare. For more information on the HIPAA Privacy Rule or the Hawaii Healthcare Privacy Harmonization Act, navigate to the links shown on the screen. This is the end of the presentation. Thank you for your attendance. Please contact us at the Hawaii Health Information Exchange should you have any questions or suggestions for additional topics.